Thank you so very much. You humble me with your presence, and I'm deeply grateful to you all. To Professor Cloney, I want to say thank you for your wisdom, which I've enjoyed the past 3 years, and for your leadership. Thank you so much. To Anne Browder, you have an exceptional foresight, and I'm grateful that I've met you on my path. To the Dean, thank you for taking time off your very busy schedule to be here. To my fellow associates, research associates at the Women's Studies and Religious Program, thank you for coming. To Professor Kane and Dr. Naz, thank you for doing this. And to Harvard University, who is the game changer in this entire journey. There are libraries, the faculties that I've enjoyed so much, to the staffs and to the students that have taught me a lot. I say thank you, but most importantly to you all. I saw people from far and near that took time off a very busy schedule to come here. Thank you so very much. I have some few disclaimers, and I make some few statements of facts, and I'll attempt to answer the 3 questions that Frank asked me to address. And so I'll just go. I understand I'm talking for 15 minutes or so, and I wanted to use the last 5 minutes to play some slide out here. Disclaimer number 1 is that I'm not an Islamic scholar. I'm not a political philosopher. And forgive me if I murdered English because it's my 5th language. I have no ideological alliances at all. I'm just a lawyer. You will hear less of hermeneutics and epistemology, maybe more from my heart to yours. Now, let me make this statement, which is a quote from Alchemist, and I turn it into some thought I had. When you desperately want something in the universe, when you desperately want something done, the universe sort of conspire in helping you achieve it. And some of you seated here today have conspired in this book. So it's a collective work of a lot of conspiration, and I'm grateful to be part of this conspiration. So thank you for this opportunity. The book is in multi-layers. It's addressed Islamic law, the national law of Nigeria, international treaties, protocols, subsequent protocols, and conventions. Now, this is some of my daily prayers, is that if I have one more day, and I breathe one more time, what is it that I have the opportunity of this one more day to do, especially to make things better than I have found it? How can I do good? How do I change my family, my society, actually at times my dream, my world? How can I change it for the better? So this is the foundation on which I stand today. And actually this is the foundation of the book. What can I do differently? Now, I come from a beautiful country called Nigeria, and I'll show you a map in a moment. This is my country, and I will speak to it in a second about the diversity of Shariah and the book. As you heard, in my other life, I was a prosecutor. So I was a prosecutor for 8 years in the Ministry of Justice. And then I was a defense counsel since 1996. And in 2008, I came to Radcliffe. And this is my 5th year at Harvard. And so this has been a journey that I'm still on. And I define my journey in this way, that I have a path that is undefined. But through time, as some of you have heard me spoken in the past, I became educated by accident as a lawyer by accident, I guess even at Harvard by accident. So it's an undefined path. But for me, on this journey, on this path, what is it that I am putting in place so that I will continue without necessarily being looking back and regretting? So I will answer the 3 questions I have. And the questions are simple. Why the book? What is in the book? And how the book? I have 3 sort of statements to make. The book is to do good. I want to change the world with the book. And the book came about, how the book came about, it's more interesting to read how I wrote the book than to read maybe at times the book, because how I wrote it was more complicated and interesting. This is actually my first gig in writing a book like this. So it has been an interesting journey also in writing. But Frank asked me to speak much more about the book. So I will say a little about the book in terms of the 7 strategies and why I wrote the book. Now, as I told you, when I became a lawyer, I was a prosecutor, and I came into cases of Shariah in 1999, when, after a long military regime in my country, the politician came in and one of the governors contested that if he is elected as a governor, he will introduce Sharia. So I came into Sharia, cases of Sharia, after he introduced Sharia in 1999. I wasn't trained as a Sharia lawyer per se. I was born and raised a Muslim. That is my background of coming into Sharia cases. But over the past few years, the years I have spent in the Ministry of Justice, I have developed interest in issues of women and children. So when the Sharia cases came about, I think I was an easy person to look for and to find and to help take the first case of Ibrahim Magazu. That was the case I handled. And then from Baria's case, I have handled about 157 cases thereabout. So when I came to Harvard in 2008, to Radcliffe, the idea was to reflect on some of these cases and to write maybe 10 pages, 20 pages. But the more I look around, the more I go to the libraries, there is a hunger and a thirst to want to know more. The more I think I know, this is when I know I don't know. So it's this hunger and thirst that culminated into keep writing, keep researching. And I have, over the past 2 years researching this book, read over 200 books. And the bibliography will tell you a little bit of the research I have done. So, but another thing I was thinking about was, what if I go back to court when I was writing the book, what will I do differently? So it's what will I do differently that's also a benchmark in writing this book, what I want to do differently. And in trying to think of what I can do differently, I thought the book will deliver that. But why the book? The book has 7 strategies, and I hope, and I'll speak to the strategies in a moment, the strategies I hope have served me well in my career as a lawyer, as a prosecutor, as a defense counsel, in ensuring that the right of the accused is protected or are protected. How to defend women sentenced to serious crime within religious law and maintain the highest standard of justice, fairness, and the rule of law was one reason why I wrote the book. But another important thing that I found on the field while I was working was the lack of books in the courtrooms. We don't have precedent in the Sharia courts. There are no written decisions. There are no computers. We don't have internet. Actually, when we were doing the case, there was no telephone. So we have to leave the villages and come to town before we're able to communicate. So there was no online resources whatsoever. So I thought this will add to some knowledge within the Sharia courts. The book started as ideas, and I researched, and to some extent, the editors were really interested because they wanted my voice, just as Anne wanted. But in the society where I come from, my voice is irrelevant to a very large extent. So I have to know how to balance where my voice comes in. So the research helped me to balance my voice within the voices of others. I had a lot of computer challenges. One of them was how to do footnotes. It was really fascinating. I want to speak to one issue or two issues in the book, but before I do that, I want to show you a little bit of the what. And so I mentioned this is Nigeria. So this is the map of Sharia state. If you could see, with the exception of this one here, the black, the dark colored, including the yellow, are the northern Nigeria. This is northern Nigeria. But out of the northern Nigeria, only 11 of the states are practicing Sharia. In Q&A, if you want to know what is Sharia, I could speak to it, but I don't want to take my time trying to go into what is Sharia for now. These are the states practicing Sharia law. And in almost all the states, with the exception of Kebbi, I have had a case or two. Like I said, I have been involved in 157 cases. This is what Anne Brady said earlier on. The president of Nigerian Bar Association, when the book was presented to them, the president of Nigeria, the attorney general, and the president of the bar. This is a cross-section of lawyers that received the book, and I was presenting it. This is the 5,000 copies donated by Harvard. And just in March, some few weeks ago, I went to Nigeria with one of our students here, and this is her and Abdul Malik. This is the presentation of the book to the Minister for Information and his PAMSEC, and I could speak to why. The interesting thing here is that this broadcast went through about 100 million people through NTA, and it was in prime time, which is 9 p.m. And the next picture is the Solicitor General and Permanent Secretary, Federal Ministry of Justice in Nigeria. These are the Sharia court judges. We call them Qadis in Gombe State, and the members of the Bar Association in Plateau Jos. This is the Chief Registrar, Sharia Court of Appeal of Plateau State. And on the right-hand side is the Chief Judge of Bauchi State. This is Anna presenting the book to the Attorney General of Bauchi, and I was presenting the book to Sharia Court Judge. I will speak to this lady who is the president of the Customary Court of Appeal. In our courts, we have about 4 legal systems. So the Customary Court of Appeal is like one of them, and she is the president in Plateau State. And the Solicitor General of Gombe State. This is the primary school where I went to. I will speak a little bit to the chief, which I also spoke to in the book, how they settle dispute without going to courtrooms. This is by far somehow one of the biggest success we had. Dr. Khalid Aliou, he is the General Secretary of the Jama'at al-Nasr al-Islam, and I will speak to that. This is Amina Lawal, one of the cases I defended, and she with Anna. And I mentioned here about the space. The Sharia court is a male space. So I just wanted to show you this slide to answer the question what the book could do. So this is what the book is set out to do, to some extent. And I'll come back to the book itself now. I want to go out of this so that focus. I started by telling you how in 1999 we had a governor introducing Sharia. What actually happened, for some of you that have not heard me speak, and I'm careful not to bore you so much, is that we always had Sharia in Nigeria. The Sharia was grounded even before the common law came. So what happened in 1999 was that the governor campaigned that if he's elected as the governor, he was going to give Sharia to the state of Zamfara. And what he did was to introduce a criminal aspect of Sharia into what always has been the civil part of Sharia. So the Sharia was limited to civil matters, matters of marriages, inheritance, children's, divorce, marriages. That was what Sharia was all about. So what he did in 1999 was to introduce basically 5 new offenses. They include, if you steal, you will have your limbs amputated. If you drink alcohol, you'll be flogged publicly 80 lashes. If you commit adultery, in this case it's called zina. If you are married, you'll be stoned to death, or any semblance of marriage. And if you are not married at all, you'll be flogged 100 publicly. So these are some of the few offenses, and one of them that was a little bit, different was the fact that if you commit hiraba is armed robbery, you'll be crucified. So those are the new offenses that was introduced by this new Sharia in Nigeria. And actually, that is how I came into the defense of the cases. Like I said, my first case is Maria. She was 13 years old. And over the years, I have handled several cases. One of the most known case is the Amina Lawal case, which is what I will speak to with respect to the book. Now, I was looking at, when I was researching and writing this book, 3 things came to mind. If I am in court with Amina's case, and the charge against Amina was she was pregnant and she has no husband, so she committed zina. She committed adultery, okay? So there are 2 count charge. She has pregnancy without a husband, and then she has a child out of wedlock, and she confessed. That is the second one. She has confessed to adultery. So that are 2 offenses that were charged, and she was convicted at trial court, at a trial. In almost all the cases, my client had no representative at the trial. First, they don't even know about lawyers, most of them. So they are in court, and they will ask them question, oh, you commit zina? And she will say, as you say so. And that will be confession. So there is some challenges there of communication. So Amina was convicted, and we came into the case in the appeal. And so what I did with the chapters of this book, which I mentioned 7 strategies, is to look at the entire cases, but use some few cases to illustrate. Strategy number 1, in Amina's case and in most all the cases, is how do we know the dynamic of a case? But how do we also know the dynamic of the society? The dynamic of the new religious law of Sharia. But beyond knowing the dynamics, how do we work within? And this is the thread that have cut across the book. How do you work within? In almost all the cases we had succeeded in court, we won the case in Sharia court using Sharia laws. We didn't look for common law to interpret Sharia. So how do you work within the Sharia? So this is very important as the dynamic the strategy number 1. The second strategy is how do you pay attention to details? In a lot of these cases, the likelihood is that there are a lot of sentiment running across different societies. Oh, we are anti-Islam. Oh, the lawyers are anti-Sharia. It wasn't about anti-Sharia or anti-Islam, which itself is apostasy. It's about defending a woman or our client subject to die by stoning. That is what the case was all about. Nothing about being anti-anything. But how do you pay attention to these details? But beyond paying attention to the details, know how to work within it. The third strategy is how do you become firm and flexible? And in the book, I discuss how do you become firm when it comes to issues of principles, principle of supremacy of the law, and argue what law, whose law? Do we have separation of state and religion? Or do we have separation of powers? Is there certainty in our laws? Do we have equality of men and female when it is only the women that have been sentenced to die by stoning and the men sort of go scot-free? What about equality? Do we have independence of the judiciary? So this is Some of the principles I sort of argue in the book, and I suggest that, we can work within Sharia and get answers to those questions. The fourth strategy is how do we become focused and stay focused? Some of you know that the cases have attracted a lot of international attention. The media are always around. But in my own context, the country I come from is different. We have what we call the professional ethics. So we are not supposed to speak to issues that are legal issues that we are discussing in court to the press. So how do we become focused in the sense that the press do not define to us what our case should look like? How do we become focused and not pay attention to West versus Islam or clash of civilization? Strategy number 5 is how do we make a plan? And actually, this is my favorite chapter, which is chapter 6. How do we make a plan? And a backup, and a fallback, and an exit strategy. Some of you might have known that I was also a target of apostasy. So how do you always want to get out of, how do you exit in terms of difficulties? And I see I have 3 more minutes. But let me conclude by sort of speaking to 2-3 issues, debunking the fact that when you think about zina, can we stone a woman today? And I argued in the book that we cannot. By our laws, we have 3 proofs of zina. And the 3 proofs are you must confess to adultery. And I argue that you cannot have confession today because of the presence of shubu'ah. Shubu'ah is doubt. Where doubt exists, and the confession must be repeated. And the circumstance of confession is laid down clearly by the hadith. Confession cannot stand the test of proof of zina. Neither will pregnancy. I argue that pregnancy alone cannot be conclusive proof of adultery. And I argued about the digital pregnancy, about the biological clock. Now, the definition of zina under the law is whosoever that is fully responsible has sexual relationship with a woman or a man that you are not legally married to. To the extent of that sexual relationship, there must be penetration. Now, my argument is that you cannot convict of a pregnancy because today, when you think about pregnancy, it's beyond some of these parameters laid out by the law itself. And finally, I said you cannot convict on zina based on the 3rd criterion in the law, which is 4 witnesses. You cannot. Now, the 4 witnesses must have seen the act of zina, uncovered, practical. But let me tell you something that the hadith said. You cannot be a witness to zina unless you are a person of good character. You are sane, you are a Muslim. No person of good character will want to come and see sexual act openly. His character is in a big question. So I argue that for some of this reason, and I want to speak to it, but I know I wanted to stop here, that we cannot say we can convict on zina today. I wanted to say more about the book, but let me conclude by speaking about, mentioning just what next. A lot of people have asked me what next. This may be one of the last presentation I have here, so you see my 2 faces. One of my faces not so happy, and one of my faces saying thank you so much. I'm currently working on my memoir, which is a memoir of this first book, of some few cases I've handled. Thank you so much. I know we are going to have Q&A. The less I speak, the more I will hear from you. So I'll turn it over to the 2 discussants. Thank you so much.
Thank you very much for opening our discussion. As Ann Browdy said at the beginning, one of the pleasures of this particular event is it's very cooperative. So the Center for the Study of World Religion, Women's Studies in Religion program, but also the Harvard Law School. So we have come together here across different parts of the university for tonight's conversation. And I'm happy now to introduce our two discussants, and then I'll turn over the program to them. First of all is our own faculty member here at the Divinity School, Ousmane Kane, a scholar of Islamic studies and comparative and Islamic politics. He came to Harvard Divinity School in July 2012 as the first, Prince Alwaleed bin Talal Professor of Contemporary Islamic Religion and Society here at the Divinity School. Previously, since 2002, he had been an Associate Professor of International and Public Affairs at Columbia University's School of International and Public Affairs. Previously, he had been a senior lecturer in the Department of Political Science at the University of Saint Louis in Senegal. He is a member of many professional organizations, including the African Studies Association of North America and the Council for the Development of Social and Economic Research in Africa. Professor Khan studies the history of Islamic religious institutions and organizations since the 18th century, and he is engaged now in documenting the intellectual history of Islam in Africa. He is also focused on Islamic or Muslim globalization. His many writings include these books, Muslim Modernity in Post-Colonial Nigeria, 2003, and in 2010, Homeland is the Arena, Religion, Transnationalism, and the Integration of Senegalese Immigrants in America. And forthcoming from Harvard University Press is a new book, Timbuktu and Beyond, Rethinking African Intellectual History. Our second respondent from the law school, Naz Modirzadeh, is a senior fellow at the law school, the Brookings Project on Law and Security, Counterterrorism, and Humanitarian Engagement Project. She's a senior associate and head of policy for the Harvard program on humanitarian policy and conflict research, where she oversees the international humanitarian law and Middle Eastern portfolios. She has led HPCR workshops and training sessions for humanitarian professionals around the world, including in Afghanistan, Jordan, and throughout Europe. Dr. Modirzadeh worked previously for Human Rights Watch and later served as assistant professor and director of international human rights law, the graduate program at the American University in Cairo. She's carried out her own field research in the Middle East and Afghanistan, focusing on the intersections of Islamic law, international human rights, and humanitarian law, and post-conflict legal reform in the various countries that she works. Her publications include policy and monitoring reports on the use of torture, the application of international humanitarian law and Islamic law in post-war Afghanistan. Her recent publications include the article, Taking Islamic Law Seriously, INGOs, and the Battle for Muslim Hearts and Minds in the Harvard Human Rights Journal. So I think you can see we have two splendid respondents to engage this wonderful book. Professor Khan.
Thank you very much, Frank, for inviting me, and also Anne. It's a great pleasure to be part of this panel discussion. I think that this book is important in many respects. It addresses a major public policy issue in an African country, which is unique in many respects also, Nigeria. With an estimated population of 170 million people in 2012, Nigeria is the seventh largest country in the world after China, India, the US, Indonesia, Bangladesh, and Pakistan. Nigeria is also the country with the largest population in Africa. Nigeria is one of 16 West African countries, but its population equals the rest of the remaining of the 15 West African countries combined, with more than 300 ethnic groups, two-thirds of which are the Hausa, the Yoruba, and the Igbo. Nigeria is one of the most ethnically diverse countries in the world. And in the Muslim world also, Nigeria is a pivotal state. with 75 million Muslims, it is the sixth largest Muslim country in the world after Indonesia, India. Not that India is a Muslim country, but in terms of population, Pakistan, Bangladesh, and Egypt. But Nigeria has also an equally large Christian population based predominantly in the south and the middle belt of the country. I don't see the map. So Nigeria is the largest country in the world with an approximate balance between its Christians and Muslims, 75 million, more or less. So how to create a sense of belonging to one nation in the giant of Africa, a country which is so ethnically diverse and religiously polarized. This is one of the greatest challenges faced by Nigerian political elites in the post-colonial period. Since independence, Nigeria survived several attempts to secession, including the civil war between 1967 and 1970, which caused the death of 1 million people, and the reenactment of Islamic Sharia law in 1999, which Hauwa discussed already, is one of the most recent challenges to the Nigerian nation, a story that the book documents very well. But I think the book is also important because in some way it's an autobiography of the author, a lawyer who worked with other colleagues to defend vulnerable individuals, including women risking death for having had extramarital sexual relations. In industrialized countries of the Northern Hemisphere, although women still encounter all sorts of gender-based problems, substantial progress in gender justice has been achieved. The reader of this book will realize that this is not the case everywhere in the world. And Ibrahim explained that for her and the team of lawyers who defended those vulnerable women in Nigeria, invoking any freedom of women to do with their body what they want would have undermined their case, the defense case. I quote her, in Mugazu's case, it was necessary for us to state that it was not acceptable for a woman to become pregnant out of wedlock. Ibrahim explained that her team had also to decline the generous offer for professional assistance from competent lawyers from southern Nigeria because they were not Muslims or because of their attire. When I conducted doctoral research in northern Nigeria in the 80s, I fully realized the importance of attire in this deeply Islamized country. Unlike in my native Senegal, where people don't really care, what dress you wear, where it's not very a big deal, as far as Islam is concerned. In Nigeria, attire is considered an integral aspect, in northern Nigeria, an integral aspect of Islamic identity. So I had to dress like Hausa people to be fully accepted in this Muslim society and to do my research. Of course, not all Hausa people wear traditional dresses, but those who do not are still called Yan Boko, or people who have embraced Western civilization. In any profession, most beginners need some mentoring to master the skills required to become successful. And when such a mentor is not available, a manual teaching what to do and what to avoid is very helpful. And I think that this book does the mentoring job that development workers striving for gender justice and human rights protections in Nigeria and lawyers in particular need to navigate in such a delicate terrain. Throughout the book, Ibrahim provides clues on how to avoid alienating actors that can cause her and her team members to lose their case. I noted reading the book that all mention of God is followed by, may he be glorified. That's the short Arabic phrase that you see, subhanahu wa ta'ala. And mention of the Prophet also by peace be upon him, sallallahu alayhi wa sallam. While these Arabic phrases repeated throughout the book might seem somewhat cumbersome to the reader, failure to follow conventions would shock many Nigerian Muslim leaders. That said, the book is clearly written with little legal jargon and teaches a lot about northern Nigeria, one of the most deeply Islamized societies in the world. Not that there are no other religions than Islam in northern Nigeria. There indeed is a sizable Christian population in the north, which had resented Muslim domination and has been struggling for their own citizenship right, these Christians, since independence. But for the majority of people in northern Nigeria, Islam no doubt provides most ingredients through which they understand their own universe. And there is a large consensus among historians that this deep Islamization is the legacy of a movement of religious reform and state building led by Ousmane and Fodio in the early 19th century, and which resulted in the creation of a polity named as the Sokoto Caliphate. And the author discussed that also in her book. So the Sokoto Caliphate was the largest and most powerful state in West Africa. It's important to mention that never before its creation and never again had such a huge territory been submitted to one Islamic authority. So, as Murray Last, scholar of the Sokoto Caliphate, has shown, the Sokoto Caliphate united Muslims across an area that was 4-month journey west to east and 2-month journey north to south at 1840 speed. It enabled growth based upon weaving cloth and a commercial diaspora that traveled beyond its borders. The intellectual contributions of its founders, of the founders of the Caliphate, to Arabic literature is unrivaled in depth and breadth in West Africa. Hundreds of scholarly works were produced by the Fodiawa, that is the community of Ousmane and Fodio who founded the Caliphate. And the legacy of the jihad is still celebrated in northern Nigeria. During the scramble for Africa in the late 19th century, 3 colonial powers divided the territory of the Caliphate, and Great Britain took the lion's share of the lands of the Caliphate. But it did more than that. The British colonial army massacred the supreme leader of the Caliphate, Sultan Al-Tahiru II, and 500 of his followers who were attempting to escape to the Holy Land in 1903. Colonial rule was then established on the ruins of the Sokoto Caliphate, and after the consolidation of colonial rule, the British undertook legal reform affecting Islamic criminal law, which was implemented in the Caliphate. They forbade the implementation of bodily punishments contained in Islamic criminal law, such as the amputations of hands, as punishment reserved for thieves, and death by stoning for adulterers. But legal reform did not extend to all spheres of life. As she rightly says, the colonial states allowed Muslims to settle matters relating to marriage, divorce, inheritance, child custody, as well as some commercial transactions according to the Maliki jurisprudence, which was the dominant school of law in West Africa. While the British and some modern-minded Africans presented this as modernization, as promotion of human rights in the name of the colonizing mission, many Muslims had a different interpretation of what happened. They saw colonial conquest and rule as aggression, as a destruction of a flourishing Islamic state and an attempt to obliterate Islamic identity. Perhaps a parallel of what happened in the Caliphate would be to imagine that the Ottoman Turks, who conquered most of the Balkans in the 17th century, had not been stopped at Vienna, but had conquered the whole Europe, killed the Pope, and reformed the legal system of their European domains or Europe. How much resentment would subsequent generations of Europeans have felt towards the Turks and Islam? This is not an argument along the lines of the clash of civilization, but to contextualize the Sharia agitation and the roots of suspicion toward Westerners in northern Nigeria. During the transition to independence in the 1950s, northern Muslim leaders negotiated with the British and their southern compatriots the institutional arrangements for independent Nigeria. They accepted the idea of a unified penal code for all the country, which Muslim leaders believed did not contradict their faith. However, other Muslims challenged the right of the British to reform Islamic law. They resented the legal changes initiated during colonialism. They considered Western law as a form of colonialism and believed that as Muslims they should be governed both in civil and criminal matters by Islamic law, which prevailed before colonialism. Now, as long as Muslims dominated the federal government of Nigeria from the 60s to the 90s, these were a minority, that is, those who favored Islamic criminal law. But when the federal government shifted to the Christian South in the last decades, advocates of return to full Sharia increased significantly. And I think that the current debate about Sharia and Muslim demand for a full Sharia cannot be understood, or can be understood only if situated within this broader post-colonial struggle for hegemony in the Nigerian Federation. In addition to teaching lawyers and development workers how to maximize their chance of delivering goods, the book summarized the most important lessons learned by the author. These have been presented, and I need not repeat them again, but I would like to make a few comments regarding legal pluralism for our panel discussion. Hauwa, you raised several times in the book the notion that the practice of Sharia law sometimes violated the principle of no crime or punishment can exist without legal ground, nullum crimen nulla poena sine lege. This is, of course, true. You write that when some of your clients were convicted, there was no offense in place criminalizing criminalizing zina. This is, of course, true if the Unified Penal Code is the reference. But for those Muslims who saw Sharia as a reference, there existed a law which was abrogated by the colonial power, which punished the offense of zina by stoning, a law which many argued, including you, served as a deterrent. The conditions to implement the punishment for zina are such that stoning happened very exceptionally. Actually, during the whole century that the Sokoto Caliphate existed, according to oral tradition, only one person was stoned to death in Sokoto in 1824, and the Sultan Muhammad Bello was reluctant to permit it. Just as the Prophet Muhammad himself was reluctant to permit that. And you mentioned several times the story of the person making a confession to have committed zina, and the Prophet kept ignoring him because he resented the stoning. So that law existed and was abolished by the British, and some still contest that. The other issue that I wanted to discuss, Sharia as opposed to modern law, still in relation to the book, where you explain really how Sharia operated and functioned. You write, and I will cite you extensively, tradition plays an influential role when understanding issues of crime and punishment in rural societies. Some societies are guided by a collective sense of responsibility, which dictates that they first attempt negotiation, conciliation, mediation, and other forms of conflict resolution before they turn to adjudication. This is completely true, not just for Muslim northern Nigeria, but for historically Muslim societies. As Wael Hallaq notes in his book, Introduction to Islamic Law, and his many, many other works on Islamic law, he said that it would be a mistake to equate the Sharia with its so-called law with law as we conceive it and practice it in our world of modernity. Sharia law, according to Halak, was no abstraction, nor did it apply equally to all, for individuals were not seen as indistinguishable members of generic species, standing in perfect parity before a blind lady of justice. Each individual and circumstance was deemed unique, requiring ijtihad that was specific. In its stability, but without rigidity, the Sharia represented an assailable fortress within which the rule of law compared very favorably to its modern counterpart. And I close the citation. This is Wael Halak. So in pre-colonial Muslim societies, the state played no significant role in the production of the law, and states where they existed might have appointed qadi or dismissed them or delineated the sphere of their jurisdiction, but they had little say on how the law was produced and implemented. Communities were self-ruled, informal mediation was the norm, and adjudication the exception. And for every case that was brought to the court, and there were countless such cases, many more were resolved peacefully through informal mediation, and you discuss really the importance of informal mediation in this area. Actors such as elders, imam, household matriarchs, and other people of authority played an important role. Likewise, qadi, what we would translate as judges, did adjudicate disputes, but they did much more. And Halak shows that the qadi was a member of the community that he served, that he oversaw the building of mosques, streets, fountains, and bridges. He inspected the operation of hospitals and soup kitchens, audited charitable foundations. And to be appointed qadi, one must be familiar with the way of life of the community in which one serves. And in the process of adjudication, the qadi would ensure to restore harmonious community relations, and that was Sharia before colonialism. And after colonialism, it became codified, and now it is synonymous for many, of barbarity and inhumanity, at least in this side of the world. But as your book shows, there are resources in place in Sharia society to defend the vulnerable. And you and your colleagues have been able to save lives working with existing Sharia laws. So the book is meant to advise lawyers and activists involved in Sharia cases in Nigeria, and it does that very well. But no book can exhaust any topic. So the benefit in participating in a panel discussion is that one can ask the author to elaborate on issues not just briefly to touch in the book. And I have the following questions for you. We know that so-called Sharia states have introduced some aspects of Islamic criminal law in their criminal legislation, but are these bodily punishments implemented? We do not have a clear sense, reading of the book, how many people were amputated or stoned, or if there was any. There was one, of course, in 1999, we know, but how many since Sani Yerima reenacted Sharia have been stoned or amputated or whatever? This is something that I would like you to discuss a little bit more. A second question is that some Muslims who were in favor of Sharia, that is of full Sharia, had become quickly disenchanted because they felt that this was not real Sharia but political Sharia. That is manipulation by politicians who, for their own political gain, within the context of power struggle between Christians and Muslims. So I would like to have your comments on this. The book also explains very well that you succeeded through private meetings with potentially opposing traditional forces, often to dilute their resistance, and this enabled you to achieve far more than what would have been possible. But my last question would be, how to break the polarization, Christian-Muslim polarization, and promote cooperation between Christians and Muslims so that Nigerians of different religion can cooperate together to promote human rights. There are resources in Islamic scriptures and in the Islamic discursive tradition that could be used to promote mutual understanding and cooperation between Muslims and non-Muslims in northern Nigeria. And I think that the work that your team, you and your team, the work that you did to save so many lives, you should be able also to find in Islamic theology or in Islamic discursive tradition resources to promote that kind of cooperation and understanding. So I will stop here and thank you for listening.
Oh, there's a clock right here. Thank you very much. Thank you to Frank and Anne, and of course to Ms. Ibrahim, most of all, for the opportunity to respond to your wonderful book. I should clarify, lest they wish to distance themselves from me, that the bio described my past position. So I'm now a fellow at the law school working on issues of humanitarian law and counterterrorism. I was just thinking, as I was listening to Ms. Ibrahim's presentation, that she is the only person I can think of that I would say, if I were ever arrested, I would want her to be my lawyer, and I would very much want her to be my friend. And I think it's that spirit, the simultaneous fierceness of her lawyering and the great humanity and empathy with which she approaches her topic that I'd like to focus on in my brief remarks. So I'll be lawyerish and say that I'm going to try to speak to three topics in my remarks. First, just to kind of situate, for those who don't work in the area of human rights and Islamic law, just how important Ms. Ibrahim's work is. I think for many who may, in the Divinity School context, hear many more presentations about Islam and Islamic law than those of us in other arenas, it may seem that this is another study or another book on Islam and Islamic law. This book is, if I may say in colloquial terms, a very big deal. And I'd like to just say a few words about why I think that's the case. Second, I'd like to suggest that there are a few ways in which the book is very radical. And on my way here, I saw that there were a number of references to a war against radical Islam. So I will say I don't mean radical in that sense. I mean radical in the sense that I think the book takes on some topics, theoretical dilemmas, and religious questions which have vexed the Islamic legal community, the human rights community, and the lawyering community for many years in an incredibly new way. And I'd just like to say a few words about what I think is new about it. And then finally, to close in the spirit that Professor Khan mentioned of the panel discussion, a few challenges I think the book sets out for us, and some things that I think I'd like to push a bit on in terms of where we go from here in terms of what these 7 strategies suggest for us. So first, I just would like to suggest that for those who work in the area of human rights, and particularly in areas where Islamic law is applied or where Islamic law is a core part of the legal system, Ms. Ibrahim's work is almost singular, at least in work in the English language. There isn't a corpus into which this book falls. There is not a lengthy tradition of writing by activists and lawyers utilizing Islamic law from within the tradition to lawyer, to litigate, to engage in real day-to-day human rights work. And I won't posit any reasons as to why that is the case. But I think that for those who have been grappling with these issues and working in many of the countries in which Islamic law is applied, the book is critically important and is also a call to other voices to share their experiences of their lawyering and their own human rights work. I think from the very beginning, Ms. Ibrahim sets out a tremendous challenge for herself and for the reader, and I just thought I would read a few words from her preface to give those of you who haven't seen the book yet a sense of the enormity of the task that Ms. Ibrahim sets out. If the reader goes away with nothing more than understanding that the approach advocated in this book is to always respect Islam, the Sharia laws, the wisdom of local people and leaders, both temporal and spiritual, be they educated or not, and an appreciation of local and national laws, as well as the international treaties signed by a nation practicing Sharia law, will have fulfilled its mission. That's quite a mission. And I think it really is the mission that many lawyers working in the spirit of Ms. Ibrahim seek to fulfill on a daily basis. She says later, and I'll come back to why I think this is important, these sound like prefatory remarks, but I think they actually, there's a thread through the book of this spirit. Let appreciation for all, from the lowest and most desperate to the strongest leaders of nations, be our foremost asset in seeking justice for our clients. Let us not allow our educations to get in the way of receiving wisdom from those who are not literate. Trust that they have great knowledge, and they too, for the most part, want to be a part of seeing that justice is delivered. So I think that as there have been many, many texts, really a shocking pile of books and articles under what I call the heading of Islam, and it's come into great popularity in the last 11 years or so, and Islam and tends to set up Islam and human rights, Islam and gender, Islam and justice, assuming from the outset that there is a tension, that there is a dichotomy between the two concepts that are going to be discussed. What I found striking from page 1 of this book, striking but not surprising given that I was familiar with Ms. Ibrahim's work, is that she never does that. This is not a book about Sharia law and human rights. It is not a book about Sharia law and women's rights. It is a book about the practice of Sharia law, but in this incredibly complex context that she sets out from the very beginning. In a context of a realm of legal worlds coming together in northern Nigeria, in her case, and the practice of what it means to actually lawyer for real people when you are attempting to have some fealty to all of those legal systems at the same time. Not without compromise, not without challenge. I don't think the book is Pollyanna-ish at all about what it means to do this, but with a real commitment that she's not going to take the easy way out. She's not going to find the easy answers to how to reconcile these incredibly complex legal arenas. I think that she brings us from the very outset of the book sentiments that many in human rights, development, rule of law, and sort of statecraft often say, but very rarely practice. And that's what I mean when I say that she sets out a challenge from the beginning that's so daunting, is you read the preface and you think, there's no way you're going to actually stick to those principles in the next chapters, right, in the 7 strategies. And what's remarkable is that she does. Another sort of sense of my sense of the sort of the spirit of the approach to the book, and then I'll focus in on a few substantive comments. She sets out a story that I think in the hands of many lesser authors would have been very easy to sensationalize, very easy to capitalize on. She describes walking into the court and realizing that she had no voice in that court. That for whatever set of reasons in the court, it was appearing her worthiness as a lawyer, her incredible professional experience was diminished by the way that that court administrated itself and by certain assumptions around gender. She says on page 140, as a woman's rights advocate, I disagreed with this general dismissal of my worth. However, it was important to remind myself that my standing before the court was not the issue at hand. Rather, This case was about something far more important than me, the fact that a woman had been sentenced to death by stoning. But this is the next sentence that's so important. The true challenge here was to attempt to work within the framework of the Sharia court to try to win her freedom. And I think that's where I'll sort of maybe make a few brief comments about what I see as radical about the book and its approach. In some ways, and I think this speaks to why this book should be required reading for any lawyer engaged in lawyering in a community context, not just those working on Sharia, the book strikes me, one, as a story of lived practice. It is in some ways in being witness to the lawyering of people like Ms. Ibrahim that we can begin to see how the legal interpretive problems that have vexed reformers for over a century may be open to change, not only through complex theory, not only through intellectual acrobatics like the sleeping fetus, but through her actual practice, through the way in which she approaches the law and the way in which she approaches her clients. In some ways, this is a book that presents itself as humble. Ms. Ibrahim says repeatedly that she is just a lawyer. And I would caution us not to be fooled by the very generous humility of her presentation. I think that it is exactly in this description of the day-to-day, it is exactly in the description of 7 strategies that focus on the hard work of winning these kinds of cases that we see majesty, that we see the transformative potential of the kinds of strategies that she sets out for us. They're transformative not only for her clients, which of course they are, but also for the broader community that seeks to find justice through Islamic law. That's the way to handle cell phones. See, I said she was fierce. It's ringing, it's out of here. I'd like to say a few words here about what the book does not say and why I think that's important. And this is, again, for me, under the headline of what makes the book radical for me in a good way. The book, and I was thinking if I had had more time to do research on this, I would have given you statistics. I think I would have been able to come with striking statistics, but that's a good way to talk about statistics, to just suggest, trust me, they would have been really starking. So one, the book does not talk about the West. And what I mean by that is it would have been very easy to say, as I think I have, as many of us who write on these topics do, well, you know, in traditional common law and Western law, adultery was proven by pregnancy. So you see, Islam is not that bad. She doesn't once talk about comparative law as a basis for justifying Islamic law in the eyes of the West. Second, she does not talk about colonialism. She does not talk about the impact of the decades, centuries of colonial rule and misrule as the basis for why Islamic law, in the particular way in which it was introduced in northern Nigeria, was introduced. Third, she does not talk about the supremacy of any law. And again, I go back to her preface. She doesn't say at any point in the book, well, of course, human rights law is the most important body of law. Well, of course, Sharia is the law that we return to, against which we line up everything else. It is constantly a process of dialogue. It is constantly a process of putting these different bodies of law in conversation. And you almost get the sense throughout the book that they're in conversation inside of her, that she is grappling with this dialogue on a daily basis as she is engaging all these different actors. Nowhere in the book does she talk about saving anyone's life, and nowhere in the book does she talk about victims. Now, I'm sure that Ms. Ibrahim has very profound thoughts about the West. I'm quite sure she thinks colonialism was very important to Nigeria's history. I'm quite sure that she's thought quite a bit about supremacy of various legal orders, and certainly she has experienced clients or individuals as victims. But I think to not talk about those things was a profound choice. And I think to focus on the dignity of every actor that you meet in this book, every individual that she encounters, is through Miss Ibrahim's eyes made whole, is not diminished to their role as victim of the state or someone about to be stoned or a handmaiden of the colonialists. Instead, we see them in their full humanity, and we see them as people who a lawyer attempting to win a case must engage with in order to determine how best to win her case. And I'll just close by saying I think there are a few challenges that remain, and I think they're challenges that are almost inevitable in a book that seeks to do so much, that seeks, indeed, as she said, to change the world with a book. One is, and I won't go into it in detail, and I encourage you, of course, to read the book, but she goes through the 10, I believe, points that the appeals court came to in finally deciding what is perhaps the most well-known case, the Amina Lawal case, the Shariah Court of Appeal in Katsina State. And it is a remarkable judicial finding. It is a remarkable conclusion, and as Ms. Ibrahim noted in her presentation, in Sharia law there is no precedent setting. And so to have this decision written and to have the outcomes of this court not only in her book but distributed in Nigeria and I hope elsewhere is in and of itself a remarkable thing. But I wondered as I read it, how does that sort of outcome become generalizable? How do you take what happened there and convince others who are struggling in similar or different contexts that it is possible for them to reach such an outcome? And of course, answer number one is the 7 strategies. But I think that it's probably more difficult than that. And I'd just love to hear more about sort of what needs to be done in the advocacy arena or in the policy arena to achieve that. And second, I found myself wondering throughout the book how much of this tremendous work is about Miss Ibrahim. And what I mean by that is the skills that you bring to this story are formidable, and your network, as Anne noted at the outset, is legend in the field. What about those who don't have access to someone like you? What about those whose options for a lawyer may not even exist? They may rely on a system to bring justice, a system that is perhaps even more flawed than some of those that you were engaging. I'll just conclude by saying I was very tempted as I was reading the book and speaking to a few colleagues about it to say that we in the field of human rights should read this book as a story about Islamic law in the human rights movement, as a story about how these strategies should be absorbed and utilized by human rights activists. And I thought, it's very easy to see this book as being pure strategy. It's very easy to see this book as being purely about a toolkit that you would then unleash in multiple countries and places. And I thought to myself, and I don't know if this is true, but my guess is that Ms. Ibrahim would caution us about turning the stories of this book into symbols or representations of people's voices. She insists throughout the book that we take people for who they are, all the people that she encounters, as individuals with their own pain, hope, complex religious faith, intelligence, and dreams. And in some ways, I think I would rather conclude that if this book means something to the human rights movement at large, it means that all of us should aspire to be, quote, just a lawyer in the way that Ms. Ibrahim is. Thanks so much. Look forward to the discussion.
Yes, go ahead.
Is it me?
Yes.
Oh, yeah, thank you very much. I don't see you. Sorry about that. Yeah, thank you very much for this beautiful. I came very late when you were presenting, but I had a chance to listen to your conclusion. Being a student as well of Islamic law and researching on Islamic criminal law and focusing on Nigeria, particularly northern Nigeria, I think to say that there is no any written documents or any record of any cases judged in Nigeria, I will find it very difficult to accept, because when I went to Nigeria, I found many criminal cases being recorded, but written in Hausa. And for someone like me who doesn't speak Hausa, I have to find someone to interpret it for me or translate it into English. So among those cases, my problem when I went to northern Nigeria is that most of the cases that human rights are advocating for justice for are mainly for women, mostly. So I'm now asking whether your strategy cover advocating for justice for men as well, not only for female, because some of the people who are trying to read meaning to our activities in Nigeria, those who have been trained in the West, they say that you have been indoctrinated, you are trying to come to serve for the West, and that is why you are looking for loopholes in our judgment. So is that the case for you in your activities in saving Amina Lawal and Sophia and so on and so forth? The second thing that I would like to ask any one of you or three of you is that the purpose of lawyering, is it to establish justice or to win the case with all cases? Thank you very much.
So culturally, it's difficult to speak about you, and it's difficult to speak about my book, but I'm so honored for the two of you. It's like, okay, shut up and sit down. So it's really heartfelt. I have not been very close to Nas. I didn't even know what they are saying, but I was like, okay, what would I say about the book? But it sort of worked nicely, and I'm humbled by that. I want to address a few things that was asked earlier on with respect to the book, and I'll try to be pointed. How many amputations we had? We had about 3 that I know. Any stoning? No, that I have no, there's no stoning. I have handled about 24 cases of women sentenced to death by stoning. We have won some of them from the prison after we got the bail. That was the end of the stories. Yeah, so these are straightforward. Is Sharia political? Okay, this is debatable, because the president of Nigeria was in Washington, D.C. during the cases, and he was asked whether Sharia is political, and he said he thinks it will fizzle out. That was when we were doing the cases, and he said it's political. But let me pose 2 or 3 things. The Sharia was introduced by a political leader, and I'm not sure whether a religious law that comes to a politician can squire into a religious law. So I don't know how to play with it, and I don't want to go into what I don't know as much. But the Sharia was introduced by a man that was seeking political office. And he said, if you elect me, I'll give you Sharia, and he did. So it was a campaign promise delivered. So is Sharia political? I leave it for your thoughts to sort of decide on that. I really don't know so much about it. But my experience has been that there's so much juxtaposing of politics and religion. You asked about the Muslim-Christian relation. One of the pictures I show was the president of the Customary Court of Appeal. We met her some few weeks ago, and that is one thing she raised. about this relationship that is so difficult. And I guess there is a lot of misunderstanding. I showed you a picture of the country, so that 2/3 of the country is in the northern part. The press is in the southern part. And the media may not understand fully about what is Sharia, so they will relate it to what they think they know from their own angle. So I think to some extent, the reporting of Sharia has been, from the perspective of our work in the field, has been a little difficult for us. And so the media has a way of coming in and interpreting things. And in this case, we have the major medias of the South, and there is no Sharia in the South. The Sharia is only in the northern part of the country. So as I mentioned earlier, there are 4 legal systems in the country. Sharia is one of the 4 legal systems, but it's not in the southern part of the country. With respect to the question that you asked about engagement and dialogue, I have given examples of how to engage, and it is absolutely true to a very large extent that a lot of our successes was not in the courtroom. It's the ability to succeed out of the courtroom that was more important. How do we win the hearts and minds of the society, of the villages, so that the clients will go back to their people? So for us, that is the biggest success. If we're able to do that, then we have sort of succeeded. And so we work more with the chiefs that you saw in the pictures. We work with common allies and uncommon allies. I mentioned in one of our discussion some of the uncommon allies we work with. Some of them are the deaf, are the blind people. Why were they important? They have the information. Remember, in some of the villages where we are working, there are no radio, no electricity, so very few radios, no TV. So the biggest informant in a society like this are the beggars. And there seems to be the blind and the laborers. So they are the most powerful people we had in a lot of circumstances that become our allies to work with. But you have to be transparent, you have to be accountable, because whatever they bring to you, they will take yours elsewhere. But it's important that we understand that a lot of it has to do with engagement and dialogue, and outside the courtroom. And it's strategic and tactical too. In one of the cases, we went to the Minister of Justice. They are the prosecutors in this case. So why should we go to the Minister of Justice? Why can't we go and defend our client? But we went to them to say, both you, the prosecutors, and as the defense counsel, we are ministers in the Temple of Justice. So as ministers in the Temple of Justice, let us give the judges something that they could make an informed decision from. And we pointed out issues of law that they drafted in the Ministry of Justice that has not been respected at the trial court. So we drop it on their decks, but let's just argue this thing in court. We just want to bring it to our attention so that we can move with it. But it's important to engage. I find engagement really worthwhile, and a dialogue very important. The last thing I want to say with respect to Aminu's question. Aminu, make a change.
No, I asked about the appeal, if we go to Court of Appeal and Supreme Court, how relevant is this strategy, and what strategy do you recommend at the appellate level where the applicable law is no longer Islamic?
The Section 1 of Nigerian Constitution says something like this. Any law which is inconsistent with the Nigerian Constitution, to the extent of the inconsistency of that law shall be declared null and void. Now, who interprets the laws between states and the Federation? And that is Supreme Court. So to the extent of the inconsistency of any law, whatsoever the law is, if it is taken to the Supreme Court, they will interpret it in the way they deem fit. But so far, most of our cases ended up at the state level. So by the time in some states you have 3 levels of appeals, In some states, you have 2 levels of appeal. But the Supreme Court, even the Court of Appeal, has refused to take some cases because the jurisdiction is limited. Sharia is state laws. Sharia is only applied in 12 states in the northern Nigeria, some of them partial. So to a very large extent, the appeal court jurisdiction is limited to issues of civil nature of personal laws. And they have refused to take issues of criminal jurisdiction. And let me address the question of precedents. So Sharia, to the best of my knowledge, the criminal aspect was introduced in 1999. And in my research, there was no much cases of precedent. And generally, the Sharia court do not accept precedent. But they accept cases when we argue it for persuasion. So if you can persuade a Sharia court with cases from other jurisdictions. Actually, when I was discussing the issue of international law, they introduced it. They brought the case of Ma'is. So it was an introduction by the court themselves. So if they can bring Ma'is, which is from the Middle East, we can of course bring international law from other countries. But it's only for persuasion. So when you say you got decision in Hausa, I don't know from where, if criminal or civil, but with respect to criminal cases, it's 1999. So, and the cases we started was 1999. So I don't know to that extent what your information is at. Let me allow them to speak.
Is there a question?
Take more questions if there's nothing.
I'm sorry, I just want to restate my question again, and for whoever would like to answer it, my question was about the reenactment of Sharia, or rather parts of it. How influential is culture vis-a-vis the prophetic or traditional, when we're looking at traditional Islam, and its ramifications for both for males in and out of Sharia courts, because it seems as though that the rules or the Islamic rules or Sharia court rules are not being applied to males.
So I showed you a picture in terms of the culture of Sharia, whether it's applied to men or not. And the cases I've handled, I say it in the book, out of 157 cases, maybe 3 to 4 dozens are cases of zina, adultery, stoning or flogging. Only 2 men were convicted. And why were they convicted? It's stated in the book. But in terms of culture, there is a lot of juxtaposition of culture and religion in some of the perception and interpretation by local courts. That is my experience. And when you put culture and religion and you mix it together, it's not a very nice mix. So to some extent, they look at Islam and say, this is what Sharia said. But excuse me, they don't even know what Sharia said. Remember, a lot of the laws we had were in English. Almost all the penal code that was codified is in English. The language of the victim is Hausa. The language of the court is Hausa. So we have to interpret at times from English to Hausa, from Hausa to Arabic, or vice versa. So in terms of when you think about how men get free, it's the system. The space is men's space. The Sharia court is men's space, and the perception of the judges are sort of not in they don't see the female as people you can engage with. In some of the courts, there are barricades. So there is a cardboard dividing the court room and the female section. And the woman is not supposed even to step into the court. You speak through a hole. So there is this difficulties you find. But remember, this is male space too. And we have to be careful how we navigate it. So instead of looking at culture, and that's what the book was saying, we try as much as possible to run away from getting into conflict on issues that will irritate the judges. Mm-hmm. I gave an example in one of our discussion about some of the strategies I use, and one of them was an example I gave when I was interviewed by a BBC reporter. And the BBC reporter asked me just one question, is story in the Quran? And my answer is, I don't think so. It was sort of played and overplayed in the radio. And they started calling on me to say I'm anti-Islam and I'm anti-Sharia. And that means absolutely, also get her. But I attempted to go and see the mullahs through the same reporter that interviewed me and interviewed the mullahs. But they wanted to see me, and they wanted to see me in the mosques. And I am dressed, but I'm not properly dressed to enter the mosques. So I was completely dressed, maybe more than her, with gloves. And I entered the mosque to visit with them. When I entered the mosque, there were 8 of them at the end of the mosque. And when I came in with the photocopies of them, 47 cases I was handling, they were sitting down and I approached them. And I approached them, I did not sit on a chair I saw halfway through the hall. I approached them, and getting close to them, I knelt down and I sat on the floor. And they chorused at the same time, stand up and sit on the chair, they said to me. And I said, how can I, your daughter, sit on a chair when you, my fathers, are sitting on a chair? This is a culture. I spoke about the dynamic of the culture. I will not sit on a chair if my father is sitting on a chair. So they asked, are you the lawyer? Are you Hauwa Ibrahim? To all questions, I said, as you please, yes, I am. Oh, you have not forgotten your culture, your religion, your tradition. No, I have not. But I said a little bit much more. I told them I'm a foolish lawyer. I told them I'm a silly lawyer. I told them, I came to them, I didn't speak about the interview on the radio, but I came to them because I think I want to do some good out there, but I'm not sure how, I'm not getting it right. And I came to them because I needed their wisdom. And I came to them because I need their guidance. Now, it's important to know this is my dynamic. This is winning them. If they are on my side, it means there may be hope for me to continue and hope for my clients. I don't know what dynamics you have here. And I said, in closure, that we know our dynamics. And we should learn to work within it. It can be, as I do in court, and you rightly pointed out, it may not be universal, but knowing our dynamics and working within it takes us one step further. And for me, my purpose, like I said, on a daily basis is what good can I do? And in closure, I want to thank you all for coming and say shalom, salaam alaikum, and God bless you all. Thank you.